question I frequently get is, do I need a trust in South Carolina? A trust offers benefits that most people would like to enjoy. In this video, we're going to talk about the main benefits of having a trust and the most common types of trusts here in the state of South Carolina. Hi, my name is Seth Levy from Heritance Law, and I'll help you determine if you need a trust or not by the end of this video. What is a legal trust? A legal trust is a fiduciary arrangement where a third party, known as a trustee, holds and manages assets on behalf of beneficiaries. The trust creator, known as the grantor, transfers their assets to the trust, and the trustee ensures those assets are distributed according to the terms of the trust document. Trust can be used for various purposes, including managing assets, providing for family members, and protecting wealth. How does a trust work? In essence, a trust operates by transferring ownership of assets from the individual to the trust. The trustee, who can be a trusted individual, a professional fiduciary, or an institution, then manages those assets in accordance with the instructions laid out in the trust agreement. Trust can be revocable, able to be changed, or irrevocable, permanent once established. Now let me walk you through the 7 significant benefits of a trust. Benefit number 1, avoiding probate. One of the most significant advantages of establishing a trust is that it allows assets to bypass the probate process after the grantor's death. Probate is the legal process of distributing a deceased person's assets under court supervision, which can be time-consuming and expensive. It's good for people that want to save their heirs the hassle, the delays, and the costs of probate. And it's especially useful for those with sizable estates or property in multiple estates. How exactly is this achievable? By transferring assets into the trust while the grantor is alive, those assets become owned by the trust, meaning they are not subject to probate when the grantor passes away. The trustee can distribute them directly to beneficiaries according to the trust terms without court involvement. Let me take you through a quick example. I once worked with a family who owned property in 3 different states. Without a trust, they would have needed to go through probate in each state, a lengthy and expensive process. So we created a living trust that allowed their assets to be transferred directly to their children, saving them months of legal work and significant costs. Benefit number 2, privacy. Unlike wills, which become public records through probate, trusts offer privacy. The details of a trust, including the assets held and the beneficiaries, remain private, away from the public eye. This is good for people that value their privacy and do not want the details of their estate or financial situation made public after their passing. And so how exactly is this achieved? Well, assets held in a trust are not subject to probate, and because probate is a public process, avoiding it also ensures that the trust's contents remain private. Only the trustee and the beneficiaries are aware of the trust's specifics. Benefit number 3, managing assets for minor children until they become adults. A trust allows parents to control how and when their children will inherit their assets. Instead of passing large sums of money or valuable property directly to minors, the trust can dictate the timing and conditions under which assets are distributed. This is good for people who want to ensure that their children are financially secure and supported until they are mature enough to handle substantial assets. And so how exactly is this achieved? The trust can specify that assets are held until a child reaches a certain age, graduates from college, or meets other conditions. Until then, the trustee manages the assets on behalf of the child, ensuring that they are used for the child's benefit, such as education or living expenses. Benefit number 4, trusts offer solutions for blended families. Trusts are particularly helpful in blended family situations where the grantor may want to ensure that both their current spouse and children from previous marriages are provided for. Without careful planning, A will could inadvertently disinherit children or lead to family disputes. So this is good for people that have remarried or have children from previous relationships and want to ensure that their assets are divided fairly between their current spouse and all of their children. So how exactly is this achieved? A trust can designate specific assets for different family members and include stipulations to ensure that all parties are cared for according to the grantor's wishes. This avoids potential conflicts and ensures that both the spouse and the children are treated fairly. Benefit number 5, asset protection. Trust can be structured to protect assets from lawsuits, creditors, or other claims. An irrevocable trust, in particular, removes assets from the grantor's estate, shielding them from legal or financial risks. This is good for people that are concerned about lawsuits, creditors, or potential financial liabilities, such as business owners or professionals in high-risk industries. So how exactly is this achieved? By transferring assets into an irrevocable trust, the grantor effectively relinquishes ownership of the assets, which means they can no longer be reached by creditors or through legal judgments. Benefit number 6, tax planning. Trust can play a key role in reducing taxes on an estate. Certain types of trusts, like bypass trusts or irrevocable life insurance trusts, can help minimize estate taxes and gift taxes, preserving more of the wealth for beneficiaries. This is good for people that have sizable estates and are concerned about minimizing their tax liabilities, especially in regard to estate and gift taxes. So how exactly is this achieved? Trust can be structured to take advantage of tax exemptions and deductions. For instance, an irrevocable trust can remove assets from the taxable estate, and charitable trusts can provide tax benefits while supporting a cause that the grantor cares about. Let me give you a quick example. I once worked with a couple whose estate was large enough to be subject to significant estate taxes. By creating a bypass trust, we were able to reduce the taxable value of their estate, saving their heirs a substantial amount of money. Benefit number 7, solutions for people with special needs. Trust can be used to provide for a loved one with special needs without disqualifying them from governmental benefits such as Medicaid or Supplemental Security Income, SSI. This is good for people that have a family member with a disability and want to ensure that they are financially supported while preserving their eligibility for public assistance. So how exactly is this achieved? A special needs trust allows assets to be set aside for a disabled beneficiary without those assets counting against income and resource limits for governmental programs. The trust can cover additional needs, such as medical expenses or quality of life enhancements, while keeping the beneficiary eligible for public assistance. Now let me walk you through the common types of trusts. There are several types of trusts, each with distinct purposes and benefits. We're going to discuss the most common ones. Number 1, a revocable living trust. A revocable living trust is one that can be altered or revoked by the grantor at any time during their lifetime. The assets placed in this type of trust remain in the grantor's control, and they can modify the trust terms as their circumstances change. This type of trust is most commonly used for individuals who want to avoid probate while retaining control over their assets. Individuals who desire flexibility in changing beneficiaries or asset distributions over time, or individuals who want a straightforward estate planning tool that allows for privacy and probate avoidance. Number 2, an irrevocable trust. Unlike a revocable trust, an irrevocable trust cannot be changed or revoked once established, except under specific circumstances and with the agreement of the beneficiaries. The grantor relinquishes control of his assets, effectively removing them from their taxable estate. This type of trust is most commonly used for individuals looking to protect assets from creditors or lawsuits, individuals who want to reduce their taxable estate to minimize their estate taxes, or individuals who are concerned about protecting wealth from future liabilities or claims. Number 3, a special needs trust. A special needs trust is designed to provide for a disabled beneficiary without disqualifying them from governmental benefits such as Medicaid or supplemental security income. This type of trust ensures that the beneficiary's additional needs can be met while maintaining their eligibility for public assistance. This type of trust is most commonly used for families who have a child or a loved one with a disability and need to ensure their long-term financial care, or parents who want to set aside funds for medical care, education, and quality of life enhancements for their disabled child. Number 4, a testamentary trust. A testamentary trust is created through a will and only takes effect upon the grantor's death. Assets are not placed in the trust until the grantor passes away, and the trust is then managed by the appointed trustee. This type of trust is most commonly used for parents or grandparents who want to leave an inheritance for young children or grandchildren, but prefer to control when and how the assets are distributed, or individuals who want to create specific conditions for the distribution of assets after death, but are not concerned with avoiding probate. Number 5, a charitable trust. A charitable trust is established to benefit the charitable organization or cause. These trusts can also provide tax benefits to the grantor, such as income tax deductions or estate tax reductions. This type of trust is most commonly used for individuals who wish to leave part of their estate to a charitable organization or cause while also receiving tax advantages, or people who want to ensure a lasting legacy through philanthropic giving, either during their lifetime or after their death. Number 6, asset protection. An asset protection trust is designed to protect the grantor's assets from creditors, lawsuits, or financial liability. These trusts are typically irrevocable and often set up in specific jurisdictions that offer strong protection laws. This type of trust is most commonly used for individuals who are at risk of legal claims, such as business owners or professionals in high-risk fields, or people who want to shield personal assets from future lawsuits or creditors while retaining some level of benefit from the trust. Number 7, qualified terminable interest property trust. A Q-tip trust allows the grantor to provide income for a surviving spouse while controlling what happens to the trust assets after the spouse's death. It ensures that the remaining assets are distributed according to the grantor's wishes, often to children from a previous marriage. This type of trust is most commonly used for people in blended families who want to provide for their spouse after death, but also ensure that their children from a prior relationship inherit specific assets, or individuals seeking to manage the distribution of their estate while providing income support to their spouse. Thank you for watching, and remember, planning ahead is one of the most loving things that you can do for those you care about. Click the link below and book a free consultation with us, and together we can safeguard your legacy.